Hello everyone, I'm back to do a little lecture on justiciability in federal court, and this is for constitutional law. I'm basically going to go do little lectures for pieces of constitutional law, and this is good for the MBEs as well as the essay portion of the California bar exam. They're quick, they're to the point, pretty much what we need to know. I actually use I go onto the NCBE site and I print out all of the subject matter outlines for MEE and for the MBE, and that's what I use to guide what I need to know for the bar exam, because there's so much, but these are just narrowed down quite a bit. Okay, so justiciability in federal court, con law lecture number 1. Case or controversy, political questions, standing, timeliness, ripeness, and mootness. And the 11th Amendment. So that's what this lecture is going to be on. So the first beginnings of a actual con law lecture. Okay, we're going to. You always have to begin all your con law essays from what I've seen on the bar exam, model answers, on all of the write-ups that I've read. We do standing and we do state action, and I will go over state action in my second lecture, and that's going to be state action with powers reserved to the state. So that'll be on the second one, but standing will be in this lecture. But we always start off with standing and state action, okay? Then we're gonna go to case or controversy. There must be an actual case or controversy in dispute. We get a lot of MBEs with this. If there's no case or controversy, then obviously it's not going to be put into the federal courts, okay? It has to be an actual case or controversy. Declaratory judgments are permitted. Those that state the legal effect of a regulation or the conduct of parties in regard to a controversy. So these are permitted. Advisory opinions are not permitted. Advisory opinions are not permitted. And you'll see in some of the MBEs where they're just giving an opinion. There hasn't been any type of actual case or controversy, okay? So advisory opinions not permitted. Declaratory judgments are. Political questions, they may not be heard by the federal courts if issue is for another branch of government. So this is about the branches of government. If there's an issue and it belongs to Congress or the executive branch, they won't hear it, okay? So it may not be heard by federal court. That's called a political question. You'll see lots of these on MBEs too. Now we get to standing. This is important for essays. Individual standing, third party standing, organizational standing, and federal taxpayer standing. I'll go through these quickly. I made a slide for each one. Individual standing, the plaintiff must prove injury, causation, and redressability. So individual standing requires the plaintiff to prove an actual or imminent injury. There's got to be an actual injury based on the facts. And causation is the injury is caused by the conduct complained of, and it is likely that the injury will be redressed by a favorable decision. Okay, so we have injury, causation, redressability. All three of these elements need to be written up for your individual standing. Now let's say there's a third party standing. P must prove individual standing elements, the ones we just said. We got to write up this first. And then we go to our second element, special relationship with the third party. So the plaintiff must have a special relationship with the third party, and difficult for the third party to assert his own rights. I've seen MBEs where the third party can assert their own rights, and so thus this plaintiff cannot be asserting the rights for them. Okay, so I've seen MBEs on this too. Organizational standing, plaintiff must prove members have standing. It's related to the organizational purpose and does not require participation of individual members. So these are the three elements for organizational standing. Federal taxpayer has standing to sue over a federal tax or spending program that violates the EC, and that's the establishment clause, and I'll get into that later. Establishment clause. So those are your standing. Individual standing, third party standing, organizational standing, federal taxpayer standing. I've seen all of these on MBE. So just know the elements, go through your facts, match them up, and see if there's any missing. If there's not, then obviously it's going to be that type of standing. They are going to have standing, the plaintiff. Timeliness and ripeness and mootness. Okay, ripeness is a case will not be heard if it's not ripe, which means there's not an actual live controversy, which we just talked about. So no future wrongs on this. This comes up a lot in MBEs. There cannot be a future wrong. It has to be right now and ripe, okay, a live controversy. Not it might happen. I read one about a beer making company, something about someone putting some kind of a restriction on the beer making company. The beer making company wasn't even going to take upon that, whatever that part of the restriction was or do. So obviously there's not a live controversy there. So that's just a bunch of MBEs on that. You can really learn that fast. Or immediate threat of harm. So a case will not be heard if there's not yet a live controversy or an immediate threat of harm. There must be an immediate threat of harm. Okay, so that comes out in MBEs a lot. Mootness. Case will not be heard if a live controversy existed at the time the complaint was filed. So the complaint was already filed, but has since been eliminated. That means it is now moot. There's nothing to talk about there. Okay, an exception is capable of repetition. So obviously, in abortion litigation, they always talk about that's capable of repetition because other women might be engaged in abortion or engaged in having an abortion and all of that. So it might be repeated by another person or repeated by the same person because they might have another baby or decide to have another baby or whatever the situation is. They use capable of repetition as an exception there, okay? And voluntary cessation by the defendant, okay? So they voluntarily stop whatever they're doing, okay? So it doesn't need to go to court. And then we have the 11th Amendment. The 11th Amendment provides immunity to the states from any federal suit against any one of the states by citizens of another state or a foreign state. Lots of MBEs on this. Seen them on essays too. Barred actions on this are actions for damages by citizens of the same state. So if a citizen suing for damages, it's going to be barred. And I saw this on one of the essays, like the whole essay was based on this. Not, I think it was, might have been 2011, I'm going to say, but I'm not positive. Not barred. Suits by states or the federal government against other states are not barred. Suits against cities or counties are not barred. And suits seeking injunctions against state officials are not barred. That's what it was. There was someone, there was a citizen of the same state suing for damages. And then also on the same essay, there was someone suing the state attorney or something of that sort. Okay, so that's not barred. But the action for damages by citizens of the same state was barred. So that's, we have to know the differences here. And then sovereign immunity. States have sovereign immunity from private damage suits brought against the state in the state's own courts. Very important too, sovereign immunity for essays. So our approach here would be the rule. Is there a case or controversy here? Is there any political questions we need to address? Standing issues we definitely have to throw in there for most of our con law essays. A quick one on standing. If they say they do have standing, then I mean, you throw a quick little individual standing, organizational standing, or federal taxpayer standing, but I would throw that in. And remember, after standing, you usually start with, let's go find that one for you guys, with the state action. Okay, is there state action? And I'll go over that in my next video. So standing, timeliness, is it moot? Is it ripe? What's going on there? If any of the facts bring this up, we don't throw in mootness or ripeness unless the facts bring this up. And a lot of the facts bring it up mostly in MBEs. And then the 11th Amendment. So are we dealing with any of these concepts in the 11th Amendment? Like I said, I saw a big essay on that, which helped me understand this quite a bit. Okay, so that's my approach. Like I said, this is my first video for con law. It's justiciability. My next video will be coming out real soon. It's going to be state action, power reserved to the states, federal powers, and limitations on state power. So that's going to be the Commerce Clause and all of that. So I'm going to do those. Section 2 is state action, Section 3, power reserved to the state, Section 4, Congress, federal powers, and Section 5, limitations on state power. And then we'll start getting into like our, individual rights and all of that, okay? So this is my first lecture. Good luck on the bar exam. And the more MBEs you do, the better you do on, your percentage will go up, and the more essays you read and the more essays you write up, it gets easier. And I make these videos for myself, really. But I decided to share them. They're not perfect. There's nothing perfect about them, but I do watch them religiously at night or when I'm exercising, and that way it just sticks in my head. I literally go on my MBEs and I remember these videos, and a lot of them, help me out in my MBEs. So good luck on the bar exam, and I'll see you in my next video.